starting with House Bill 6637, sponsored by Representative Henrys, an act related to criminal offenses, sexual assault. It establishes criteria for the criminal offense of sexual assault when the victim is in the custody of a peace officer, provided that a person convicted of custodial sexual assault would face imprisonment for not more than 3 years. Representative Henrys, welcome to the Judiciary Committee. The floor is yours.
Thank you, Chairman and committee members. I just want to start by saying that I'm extremely grateful for the feedback and the discourse we had last year from my peers. It was really good to have those conversations around this bill. So because of that, I'll keep most of my points pretty to the point, and I'll lend a lot of my bill's importance to that of the witnesses that I have here testifying. But some of the things I want to bring up is that in Rhode Island, as we stand today, it is still legal for law enforcement to sexually assault people who have been arrested, detained, or in their custody. That also includes people who oversee probation as well as parolees. In power dynamics like this, with law enforcement and authority, there is no such thing as consent. Permission is compromised in the face of authority. I know that was a big topic that we had in the last hearing, and I heard a lot of, the debate about how do we define consent? What does that look like? I will say that in opposite of consent, there is coercion, and it is defined in the chapter 1137, the definition of coercion, and it can be a threat. The threat doesn't have to be physical. It can merely be the presence of the authority, and to that point, I think that this falls right in line with chapter 1137 for the sexual assault bills. This is also a charge that's only applicable if other sexual assault charges cannot be applied to the case as defined by chapter 1137. So in a good sense, this is just a nice kind of safety net to kind of close the gap with this loophole that we have with sexual assault cases. In my mind, it really just isn't appropriate, and if I look through most of the list of careers, there's not many places or spaces in which it is appropriate to have sex with anybody while you're on duty or while you're working. So I don't understand why this has been any different. Most of the time when I bring this bill up or that I'm presenting it, a lot of people outside of the political world are kind of looking at me like, this hasn't passed, this is an actual bill, this is something we have to talk about, to which I have to look them in the eye and say, yes, unfortunately it is. It's something we have to address and talk about and kind of get through the nitty-gritty with. The other question I got asked last year was, why only 3 years? Based off of my conversations with the ACLU, they wish to keep the bill within the reason of other sexual assault bills. So that's in line with first and second degree sexual assault. They didn't want to go much higher or much lower, but they did want some level of punishment, but at the same time did not want to be extremely carceral in nature. I also brought up the case of Anna Chambers from New York. She was 18 years old. She was arrested. I believe the charges were for weed possession. The 2 officers that arrested her sexually assaulted her, and they got away with just probation. I think a lot of people in this room can agree that probation just isn't enough for a sexual assault case, and that we really have to consider what it looks like to have justice for these victims. Another thing that got brought to my attention is that a lot of people go, is this actually a problem that we're having? Is this something that Rhode Island needs to really address? Just as of December 7th, there was actually a case. Justin M. Toy was put for charges for 3 counts of sexual relations as a correctional officer with inmates in the ACI. I just want to take the time to actually really thank the ACLU and COYOTE, an organization who's really helped me to kind of get a full grasp of this kind of legislation and what we're working towards, and also Senator Sam Bell for their partnership on this bill. And I really think it's time for Rhode Island to become number 17 out of the 16. So any questions?
Any questions for the sponsor? Yes, Jose.
All right. Green must mean it works, right? Not really a question, just a comment. Thank you, Representative Henrys. I think this is a great bill. I'm proud to co-sponsor with you. I think that this issue of consent is obviously a very important one that our society is grappling with. And this bill is obviously probably one of the more extreme examples of what we think about a consent, but this is actually a concept that comes up all the time. For example, in different states and different jurisdictions, an officer or law enforcement won't have to read you Miranda rights unless you're in custody. which means that you're not free to go. And how many times don't we see interactions between citizens and law enforcement that is not very clear, right? The person who's a citizen will say, well, am I free to leave, or can I leave? And even in a situation like that, like, it's not clear what the authority is, what we have the consent to do. And so this is just, it's almost striking to me that it's not law already. So I want to thank you for your leadership on this. I look forward to working with you on it, and I hope that we can turn this into law.
Thank you.
Representative Roberts.
Thank you, Chairman. So I'm sure that this bill was well intended, but I had some concerns with it. I wrote them down. So I want to tell you that, first of all, this singles out a profession for criminal liability that is in addition to current laws on sexual assault that are applicable to everyone. And secondly is that it reduces the current penalty for sexual penetration from a 10-year minimum to a 3-year maximum imprisonment. And I'm just not sure if you've really thought about coming from the position of a victim. That may be considered like a slap in the face, because penetration, that's like the worst.
Yeah.
All right, and this seriously creates a lot of serious damage to a victim. Okay, so in most cases, if you were to prosecute and take this person to court and were to come out successful, they may be given 10 years, but in most cases it will be suspended. So in this piece of legislation you have here, you're saying 3 years maximum. So what that says is that, you know, they may be sentenced to 3 years, but it could be suspended, they get a slap on the wrist, and that's it. And it's really, I see it as a slap on the face to victims.
I understand what you're saying. And at first, when I read the bill, it was one of the things that struck out to me as rather alarming as well, that the time was a maximum of 3 years. However, when I was talking to Steve Brown of the ACLU, I came to understand that, like I mentioned earlier, is that the bill would only come into application if that first degree wasn't applicable to the case. So that 10 years is still on the table. The 3 years is literally like last resort. This bill is just like that last bit of safety net for a victim. So let's say they go to court, they go through the process and they don't get that charge, they still should have some type of level of justice be readily available for them. And while I do like to think that we could maybe up it, that's something I'd like to revisit and maybe have a conversation about. But as it stands right now, I think the idea of having the first degree or the second degree be applied to the case would be substantial for a victim.
I appreciate your comments.
Thank you.
Okay. Any further questions? Oh, yes.
We haven't had a chance to talk
I
about this.
know.
I appreciate where this bill's coming from. I can't support it in its current form for a variety of reasons. Not the least of which, and I don't mean to, I'm not going to pick it apart, but 7 lines in, and it says that the victim is detained and under arrest. What does that mean? Under arrest. And I'm asking rhetorically because the courts have spilt gallons of ink trying to figure out what it means to actually be under arrest. It is not an easy legal concept. And you'd be asking a jury to say, beyond a reasonable doubt, so-and-so is under arrest, where maybe they aren't. Maybe the judges that are responsible for figuring that out, who can't figure it out on a daily basis, case to case to case, would differ, right? And when we convict somebody of assault, when we convict someone of a violation of the criminal code, where we say not only what you do to this other human being is reprehensible, it's so reprehensible that it's an injury to us, all of us, and therefore you must pay us in addition to the victim, typically through jail time. That's why when we convict someone, we do it with evidence that is beyond a reasonable doubt. Not beyond a shadow of a doubt, but with a firm and moral conviction in their heart that the law was violated. And when we write a law that is iffy, that is vague, that has problems, which it does as I go through the rest of this, not any fault of the sponsor, but this is what we're trying to do here. I think it's a little bit of a circle in a a square peg in a circular hole. We could get at this behavior in other ways without having to add to the criminal law. And I think maybe where we already have sexual assault firmly defined, and we could get at this in other ways, such as pulling the officer's certification to be a police officer in the state of Rhode Island, essentially barring that person from the profession. And then if there is conduct that violates the law that's on the books right now, well, then that person could be prosecuted as well. And consent is on the books right now. And consent is a malleable concept, is litigated, 5-6 times a month in the Superior Court in Providence. What is consent? What does it mean? What does it not mean? And certainly in a prosecution for sexual assault under today's law, if the perpetrator happened to be a police officer in uniform and the person was in custody, that relationship would play into the question of consent, and the jury would be able to consider it today. So that's my 2 cents, and I think I applaud the effort. I think there's other ways to go.
Thank you for your comments.
Any other questions of the sponsor? Thank you, Representative Henrys. We've